Hi, and welcome to Legal Considerations for LGBTQ Parents and Parents of LGBTQ Kids. My name is Charlie Arrowwood. I use they, them pronouns. And while this training is informational and does not constitute legal advice or create an attorney-client relationship, I do hope that it is helpful. We'll be talking about considerations for LGBTQ parents, so primarily around custody rights and parental rights, as well as document changes, and then considerations for parents of LGBTQ children, including disclosure of trans status, medical care, schools, document changes. The biggest thing that folks are concerned about as far as parentage is concerned is, are my parental rights safe? Do I have the authority if we go somewhere that is not New York, where I won't lose my right to make medical decisions for my child? I won't have a problem going through airport security. The biggest thing is to ensure that you have something that is legal and binding and portable. So you can have an agreement between people that is outside the court system that won't necessarily be recognized everywhere. You want to make sure that the document that you have has been okayed by the courts so that you can use it in other places. And there's no need anymore for a full second parent adoption. You can actually now petition for an order of parentage. There's no home study anymore, no fingerprints. It only takes about 3 months. And then at the end, you have a document you can go other places with and be sure that your parental rights are secure. If you're not married, so, when you have a baby within a marriage, there's a presumption that there's an intent to co-parent. If you're not married, you need to show evidence that you both intended or all intended to co-parent. So keep records even when things are good. If you have a known donor, so you're not going through a sperm bank or any kind of medical channels, and so there's no paperwork associated with that, you want to consider a known donor agreement, whether you're married or not, frankly, because it just ties up loose ends. It puts everyone's intentions in writing, and it just makes everything kind of more clear. There is a reality that the biological parent is often favored in the court system over the non-biological parent. So you want to make sure that all this evidence is kind of lined up and ready to go. When both parents are LGBTQ, it's not likely that one will use that status against the other. Usually using LGBTQ identity against a parent happens where there's a previously straight assumed couple and one of them transitions and the other parent says, well, this isn't healthy for my kids, or they want to use it against the other parent to gain custody. The court is focused on the interests of the child. So you want to keep your argument to what is in the child's interests and use expert witnesses saying that, it's not inherently not in the child's interest just because a parent does transition. And again, you want to have that agreement showing evidence of intent to co-parent either way. As far as documents for parents, it used to be the case that if you had a child born in New York State and your name was on their birth certificate and you were designated as mother or father, you were not able to change your information on your child's birth certificate unless you got a special court order separate from your name change order ordering the Department of Health to make this change. Now, with the Gender Recognition Act, which goes into effect December of 2021, you are explicitly allowed to make this change. So if you have a child and you're designated as mother, you transition, you would like to update your name and make yourself father on that birth certificate, there is now a form that you can do that with. It's on the State Department of Health's website. This is what it looks like. There is a different form for folks who are over 16 when you want to change the birth certificate of someone over 16. But now this is something that you're able to do. And you can also ask for them to designate you as parent rather than mother or father. As far as considerations around LGBTQ children, medical care is a big one that I get a lot of questions about. particularly if one parent is on board with medical transition and the other parent is not, or neither parent is on board. If that's the case, honestly, talking about it is the kind of best course of action. There are some providers who will provide hormone blockers or hormone therapy without consent of both parents or without parental consent, depending on how old the child is. But going to family therapy or mediation and coming to a mutually agreeable kind of place is generally a pretty healthy way to go. And if it doesn't take too long, especially in the context of hormone blockers, everyone kind of ends up in a better place. Another thing that pops up is health insurance denials. So for example, if you have a 16-year-old trans son and they would like top surgery, sometimes insurance companies will deny coverage for top surgery just because the person is not 18 yet. And that's the case for hormones as well under some plans. There are also denials based on medical necessity, or the insurance company says the thing is cosmetic. And then some plans just exclude trans care completely. The way that you tackle each of these is a little bit different. So reach out to a legal services provider who can help you out with this. But just to give you an idea of the roadblocks that come up in the health insurance context, those are all denials that we see. Provider discrimination based on trans status is prohibited. So if you have any issues with a doctor's office, a hospital, either not providing care or saying something discriminatory, treating you differently, that is something that you should file a complaint with the state about. Insurance companies also cannot deny coverage of sex-specific care. So, and this applies to adults and minors all the same. If you have F on your insurance for female and you need something like a prostate exam, the insurance company might initially kick that back and deny it because the computer says, why does someone who is female need a prostate exam? Well, they're not supposed to do that. So if you contact them, inform them that you're trans, they should be able to put a modifier code on your account so that that kind of care doesn't keep getting kicked back. If it continues to be a problem, or they are treating you in a way that you're uncomfortable with because you're dealing with a trans person, that also warrants filing a complaint. As far as disclosure, make sure you have a conversation, many conversations, frankly, with your child directly. Where are you comfortable being out? When do you want me to correct people about your name, your pronouns? Are there places you don't feel safe being out? People you don't want me to discuss this with? Make sure that as your child is coming out themselves and figuring out their transition, that you're communicating about how they want to convey that to the world. It's their story. And so you want to make sure that you're not oversharing or sharing things that they would otherwise not share with certain people, putting them in an unsafe position, anything like that. As far as name changes, in New York, you have a common law right to use whatever name you want. You can't update documents without a court order, though. So a lot of parents ask, when should we do this name change? If the child is solid on the name that they want to use, the earlier you change it, the better, because you can get the college applications done in the right name. They can get their first driver's license. They can establish credit. The earlier you do this, the less stuff you have to change on the back end, and the less rooted in their old name their kind of existence is. Only notice to parents is required under the name change statute. So you do need to notify a person's parents if they are under 18, but anyone can file on their behalf who is over 18. So it can be filed by someone called a next friend, not necessarily a parent. If the person has someone over 18 that they're comfortable with, they can file, they can notify the parents, and then the court will give them an opportunity to come and voice why they don't want the name change, or maybe they won't even show up at all. But ultimately, the standard is that the child's interests are substantially promoted by the change. And for trans children, it's pretty clear at this point, based on research, that it is in their best interest to make this change earlier rather than later. Document changes generally require a signature from both parents if the person is under 18, although some documents do allow for the minor to sign on their own or only one parent, as long as you show that there's notice. Really depends on the document. But at this point, you can obtain an updated document in pretty much every context that reflects the child's name and gender marker in New York. Schools are required to allow access to restrooms and sports, public schools at least, in New York, and public accommodations and non-discrimination law applies in other places besides school, in addition to school. The Gender Expression Non-Discrimination Act that was passed a couple of years ago requires that you not discriminate on the basis of sexual orientation or gender identity. So trans status is a protected class in New York in most circumstances. And that means that you can't be discriminated against based on the fact that you are trans. If you run into any issues with public accommodations or schools, document everything as it happens in writing with a timestamp, keep whatever records you can. And you want to file a complaint with the Division of Human Rights if there is an issue. These are a handful of resources. Just wanted to provide these for a little more information. If you have any questions, you can reach out to me, charlie@arrowwood.law, and I'm happy to connect you to resources anytime. Thanks so much.